Good morning. Good morning, everyone. Good morning, Advocate Maema.
Good morning, Chairperson.
Advocate Chauke, good morning. Advocate Maema, you proceed with your evidence under oath.
That is correct, Chairperson.
Thank you. Advocate Batohi.
Thank you, Madam Chair. Madam Chair, in the last 5 minutes, there has been some progress because what has been in dispute has now been accepted that is no longer in dispute about the contents of the dockets that have been analyzed. We analyzed 7 yesterday. We had to make a decision whether to analyze more. My learned friend tells me that they will not be placing that material in dispute anymore. But perhaps he should speak for himself.
Advocate Mchene,
Yeah,
on behalf of the evidence leaders.
Yes, Madam Chair, we have discussed it with Advocate Mutlamanyane, and Madam Chair, we will not be disputing the contents of the dockets, those that have been analyzed and those that have not been analyzed. We accept that the contents of those documents are as they are, and the panel can take notice of them.
Do not know whether the NPA team would like to say anything. Please come forward to, you can borrow us that moving mic.
Thank you, Madam Chair. We're saying that not at this stage.
What do you mean, not at this stage?
That the dockets that are remaining would be contested.
You need to make up your mind because it will make it difficult for them to make an assessment whether it is important to proceed with the remaining part of the dockets, particularly because they may plan to deal with the different matter, and this witness may be excused sooner than we had anticipated.
As of yesterday afternoon, the discussion with the evidence leaders was that perhaps they should request a list of issues that the Advocate Chauke's team intended to lead evidence on, so that the team can decide whether they would need to have that proceeded with or that they accept the contents as they are and they will not dispute anything in relation thereto. So when the discussions were made, there was no indication whether there will be an agreement on that aspect. So matters were left at that.
Were you part of the discussion 5 minutes ago?
No, I was not part of the discussion 5 minutes ago.
Yes, I appreciate that your senior Advocate Halley is not here.
Yes.
I'm just affording you this opportunity because you are representing the NPA, and it doesn't appear to me that there can really be any dispute because the dockets are what they are as they stand, unless of course you're going to call evidence to the contrary.
Thank you, Madam Chair. Unless perhaps I get just quick instructions from my senior and client. But as I say, the indication was that at least if we get pointers of issues that they still needed to lead evidence on, and the team would decide whether they want to accept and admit the evidence as it is.
Can I just check? You do have copies of the dockets?
Yes. Yes.
And we got the dockets from NPA.
Yes. Yes.
Obviously, you would have gone through them.
Yes.
And you would have identified issues that you dispute from the dockets.
Yes.
So maybe instead of having the Chauke team that is now in the process of leading evidence, having to make time to write down all the issues that they intend to lead, because obviously if they have 28 dockets, they would intend to lead evidence on 28 dockets. But it would be better if the NPA were to say in docket, in count, docket number, case, whatever, we dispute 1, 2, 3. And yeah, because the documents are yours, they come from you. So you should know them better than us. I take it, maybe it would be better if you were to still persist that you are going to oppose some of the issues. Maybe you should just alert the Chauke team so that they deal with it, and we obviate the need to have to recall a witness or to have to revisit any evidence. Thank you, Chair.
Thank you, my sister. Yes, I agree. And but for now, we will proceed on the basis of your for now.
Yes.
With the view that you will revert. You understand why we are here.
Yes, I do, Madam Chair, and I appreciate that if we can proceed on the basis that at this stage at least there is no indication on what we are going to need further evidence to be led on, and be allowed later on to indicate.
The affidavit of Mr. Maema is in front of you.
Yes.
You know exactly what he's saying about those dockets.
Yes.
If there's any issue that arises from those aspects that he's raising in his affidavit, which we now have, all of us have read, you should be in a better position to say to Advocate Nkabinde, we will dispute this and that, so that then he can focus.
That is so, Madam Chair. We will do that.
Yes, thank you. Advocate Batohi.
Thank you, Madam Chair. Advocate Maema, good morning. We will...
Let me remind him that he is under oath. I beg your pardon, Advocate Batohi. Counsel, you are still under oath.
That is correct, Chairperson. Thank you.
Thank you, Madam Chair. We will
Good morning,
skip,
Chairperson.
yes, we will skip everything from the last case that we dealt with, which was the case of Peggy Temba, to paragraph 345.
I am there, Chairperson.
Yes, the heading there is legal framework for racketeering.
That is correct, Chairperson.
Yes. Now, the a number of concepts that one needs to dissect in dealing with the concept of racketeering. The first one is the concept of an enterprise.
That is correct, Chairperson.
Can you explain why you believed the Ketumano unit qualifies as an enterprise under the poker legislation?
Chairperson, the concept of an enterprise, I deal with it on page 1-86, paragraph 350.3. An enterprise in terms of the poker legislation is defined to include any individual partnership, corporation, association, or other juristic person or legal entity, and any union or group of individuals associated in fact, although not a juristic person or a legal entity. So the enterprise is that common vehicle through which all the offences are committed, but it is the members of the enterprise might differ from incident to incident, but the fact is the enterprise advances the objectives of the enterprise.
Yes. Now, there is also an associated topic around the concept of an enterprise, which is whether or not it's necessary in law to qualify as an enterprise, that it must be performing illegal or unlawful acts. Remember that the finding made by the de Kock panel is that Ketomano is not an enterprise because it was established for lawful purposes.
Well, Chairperson, you find an institution established for lawful purposes, which is just a cover. But when in real fact, there are other businesses that they engage in which attract criminality. So whether it is a lawful institution or an unlawful institution, it can be an enterprise.
Yes. Then there is also another element to it, which is who is inside the enterprise.
Yes.
And how do you decide who is inside the enterprise? Can you explain to the panel how is that exercise to be undertaken?
Well, you look at the day-to-day activities of the enterprise. Like you say, Council, the members of the enterprise on any given incident might be different. But whenever an individual participates in the activities of an enterprise and advances the objectives of the enterprise, then he associates in fact with the enterprise.
Yes.
So you can charge him as part of the enterprise.
Yes. Thank you. Now, just to apply then these concepts of an enterprise to Ketomano
Yes.
specifically, can you help us with that?
Chairperson, we as a team, as a prosecution team, my team, together with the police, the DPCI, and IPED, as well as Advocate Musing from National Office, we spent, I think, almost a week debating this issue of an enterprise. When one looks at the provincial organized crime, we thought, particularly because of the involvement of General Johan Boysen at provincial level, we thought, could the entire provincial organized crime be an enterprise? But when you looked at the role of Colonel Aya, who was then removed, and then Boysen comes down from province to assume the position of Aya, and the serious violent crime section of Ketomena is the one that conducts all these activities. Then we concluded that the serious violent crime section in Ketomena is actually the enterprise. And because Johan Boysen managed their activities, supported them, and made sure of their continuity, we then settled for serious violent crime based at Ketomena as the enterprise.
Yes. So the one way of looking at it, so what happens, for instance, there are some sins that I've noticed here where the members of the National Intervention Unit come and play a role.
That is correct.
Yes. And then there are also some scenes where you'll find a member from, we looked at one 2 days ago, from Kranskop.
Yes.
comes to the scene, and then Cato Manu comes and they remove them.
Yes.
So although you've got in total 28 of these incidents,
Yes.
23 of the incidents, 28 deceased, it expands and contracts by the addition of people from outside of Cato Manu.
That is correct.
Just explain that. How does one deal with that?
You see, for one to be part of the enterprise, you must participate in two or more incidents. So in some of the incidents, we find one or two who participates in one or two. But we to be charged with 21E or 21F, we needed a member of the enterprise to participate in more than one incident.
Yes.
Yeah. So those that we charged with 21E and 21F, we are convinced that they had a role in more than one incident.
No, we'll come to the participants
Oh.
because that's a different topic. I'm still trying to understand the enterprise itself, how you saw it. So you say that the inner core of this enterprise was the Serious and Violent Crime Unit of Cato Manu.
That is correct.
And we know the members of that unit.
Yes.
Yes. But I'm saying sometimes if there is someone from outside of that unit,
Oh, now I get you. Yes. Who then comes?
Yes.
Then you look at the role of that person.
yes,
And how the role of that person, what do you say, advances the objectives of the enterprise.
yes,
Yes. Yeah. And if whatever role that he participated in advances the role of the enterprise, then you can charge him.
yes. So, but how would you know that his participation? Because you see, if you said, listen, my enterprise is this group of people,
Yes.
because they are pursuing a same object over a sustained period of time.
That is correct, yes.
But now there's someone from outside who comes in on one or two occasions. You say, well, that doesn't change the character of the enterprise. I suppose.
That is true. Yes. So what you do is you then charge him with the role that he played, not in terms of 21E or 21F, but as you specifically include him in the incident where he was
I
physically
see.
involved.
So that would not be a racketeering charge.
That would not be a racketeering charge. Yes, it would be a predicate offence.
Because the racketeering charge requires that enterprise to be
That is
defined.
correct. Yes.
So if you charge someone who came from NIU or NIT, it will be because they've committed murder.
Yes, they were present at the particular scene where one of the deceased was killed.
But not because they were in the racket.
Not that they were in the racket. That is correct, James.
In that event, he could be charged under the common purpose principle.
That is correct, James.
Yes. Thank you very much. Now, all right. Is there anything you want to add on the definition of an enterprise and why you believed it applied to the Serious and Violent Crime Unit of Cato Manu?
Chairperson, I think we have dealt with it, yes, sufficiently.
All right. Thank you.
Thank you.
There are further concepts that must also be dissected. The first one you deal with in 350.1, pattern of racketeering. Just explain the concept. We will deal later with how it applied to Cato Manu.
Chairperson, in terms of Section 1, a pattern of racketeering activity is defined as the planned, ongoing, continuous, or repeated participation or involvement in any offence referred to in Schedule 1, and it includes at least two offences referred to in Schedule 1, of which one offence occurred after the commencement of this Act, and the last offence occurred within 10 years, excluding any period of imprisonment after the commission of such a prior offence referred to in Schedule 1. So the pattern of racketeering activity would look at those the commonality in all the incidents. When you say, for instance, in Ketomena, one thing that is common in most of the incidents is raiding early morning when people are asleep, but predominantly one similar character in the manner of their conduct is planting of a firearm, placing a firearm at a place where the deceased is killed to create that threat threat impression. You'll remember at one of the incidents when they were in the Kumbi, Mostert ran back to the Kumbi during the raid to go and get his Bombay, because the Bombay is an essential element of the pattern of racketeering activity.
You know, I thought of this word Bombay yesterday. In the townships, it's used to indicate something fake.
Yes.
But in the villages, it's actually not Bombay, it's Mbai, which is a machine gun.
Yes.
Anyway, I thought, so it's actually Mbai.
Yes, but you see the Ketomena guys refer to it as Bombay.
Yes.
Because what it signifies is a spook.
Yes.
Something that was not there, but that is there.
Oh,
So it wasn't there during the commission of the offense, but it just suddenly appears. So
it
they
was
make
used
it
properly
appear
as fake.
as fake. They make it as fake. That's how we understood their concept of Bombay.
Oh, okay.
To
So
me,
it's
yes.
the Bombay gun.
It's a Bombay.
It's a
gun.
pretend gun.
Pretend, yes. It wasn't there, but it's there.
No, I understand. All right, but let's just come back then to this concept of a pattern. So you say there has to be a similarity in the activities of the group that is
Yes.
participating in the enterprise.
Yes.
And you've identified two similarities, but we'll come back to those. But I just want to come back to the words of the statute. So the first one is the planned.
Planned, yes.
Yes, let's just talk about that. What does that entail?
Well, planning it's a concept that we have in conspiracy. The coming together of individuals planning to achieve a particular objective. So there must be some coming together of minds. We come together and we plan and we say, this is what we hoping to achieve.
And why do you say that there was planning in respect of the SVC of Ketomani?
Chairperson, there was planning. They have to ensure that they have vehicles, they have equipment, they are able to execute, and yeah, there was a higher degree of planning in the activities of Ketomani.
Yes. And that's exhibited by the degree of organization in the way in which the executions took place.
That is correct. If you look at consistently most of the scenes, Eva would consistently be used to work on the scenes and to clean the scenes up. And there's a penetration team.
Yes.
Penetration team is those that get to the door, they knock, and we call them the scope and boboza. They break down the doors. Those are the experts. And we have one or two who are good in shootists, who excel in target shooting. If they want to shoot your ear, they will shoot your ear. If they want to shoot your fingers that are holding the gun on the holster, they will do that. So there's a particular plane, and there's particular individuals that are given specific roles that they must execute.
Yes.
Yes.
I mean, I suppose even the concept of planting a firearm, that's not a random thing.
It's not a random.
It's part
Yes.
of the...
It's part of the plane, because there you see Mostert running back to the Kumbi. Underneath the driver's seat of the Kumbi, there's a bag containing firearms, and he picks one there and he goes to the scene and he throws it on the scene.
What about the identification of the targets to be executed? Is that part of the plan?
It is part of the plan, Chairperson. It started when they came back from Kranskop.
Yes.
Yes. Because after Reddy was killed, after there were two that were killed prior to Kongo.
Yes.
And after Congo, they said, no, it's enough. We're not going to let criminals in KZN take over the province. We will deal with them, and we will deal with them decisively.
Yes.
So the plan started just after the killing of Soup Congo. They said criminals are not going to take over in KZN. But it is right for the police to say criminals can't take over. Yes, but what do? You make sure that you collect evidence lawfully in terms of the Constitution, you present the evidence before court, and you convict the criminals.
Now, I mean, you've said twice that this began after the murder of Superintendent Konco.
Yes.
There is the evidence of Mr. Danikas, who traces the events from 2001.
Far earlier, yes. Yes.
Which was one of the pieces of evidence in front of you. What do you make of that?
Chairperson, we looked at that evidence, and in terms of poker, it is similar fact evidence that you can lead that is admissible. So even incidents that happened before, although we have a period that we focus on, but you can refer to a previous incident, you can refer to a previous conviction. This is one of the instances where even a previous conviction is allowed to be disclosed before conviction.
No, but I'm saying in terms of when this conduct of Keito Manu began, when you say it began after the murder of Superintendent Kongo, there is a witness who actually traces it earlier than the murder of Superintendent Kongo. I understand the issue of similar facts. We can deal with that later, but
yes.
For now I just want to deal with your point that the planning to execute, which we are still dealing with the concept of planning, the planning to execute took place after the murder of Superintendent Kongo. How do you place that in the context of what Mr. Danikas is saying, that actually we had been torturing and killing suspects since 2001?
That is correct. Chairperson, I'm saying it started early, but the tip of the iceberg was the killing of Supcon. Because what happens when it was happening prior to 2008 at a snail pace. After the death of Supcon, you see it picking momentum, and it not only picking up momentum, also the vigor and the enthusiasm, the rigorousness increases.
Yes. Thank you very much. Then you have the second word. It's planned. It's also ongoing. What does that refer to? Ongoing.
Ongoing says it must be. It must happen over. It mustn't start and then starts. That characteristics denotes that it's something that takes place over a period of time.
Yes. So in other words, it's not one incident of a policeman killing a suspect, but it's several incidents.
Several unending incidents. Yes.
And then those words appear to be similar to continuous or repeated, which is also in the statute.
Yes.
Can you just explain what, I mean, because ongoing, continuous appear to be meaning the same thing, and repeated also seems to be meaning the same thing.
Yeah. Well, all that they denote is that it's like an object falling from the mountain. It just keeps on rolling. So it is incident after incident after incident. So they are continuous, repeated, ongoing. Yes.
Now I want to ask you here, because there are some findings made in the DICOC report which are in conflict with your approach. Finding one is that continuous means it must be unending into the future. So in other words, you can't say it was continuous between 2008 and 2011, which was the scope of your indictment. It must also be continuous beyond 2011, way into the future. Now, what do you say to that?
No, it is an incorrect analysis of the principles, because what would happen, although it is ongoing, continuous and repeated, something will happen that will apply brakes to this object that is rolling down. If it hits a rock and gets stuck, or if the car that is going, the petrol finishes, then at some stage it comes to an end. But the mere coming to an end of an operation, that does not mean it disqualifies it from
Yes. Are there
from
also not
from the characteristics.
serious implications of their finding, which is if a person or a group of persons who constitute an enterprise commit acts of racketeering between 2005 and 2010 and they stop, maybe the leader of the enterprise is killed.
Yes.
The NPA then comes in 2011. On this concept that it must be continuous into the future, what would happen?
Then it would mean you disqualify yourself from dealing with that as an enterprise.
Yes.
So it doesn't make sense.
Yes.
Yes.
Now, is there anything to be added on the word repeated? We've dealt with continuous.
Repeated also, it's the same, over and over again, thing happening over and over again.
Yes. Now, is there anything you want to add on continuous, ongoing, and repeated in relation specifically to Cato Manu that you haven't said?
No, Chairperson. What we saw their conduct fitting the definition of a pattern of racketeering activity as defined in poker. And this was a debate that we had amongst deputies, among senior state advocates, amongst General Mabula, Mr. Engars. Although the concepts themselves are not very, the police do not speak this concept. Prosecutors also do not speak this concept. I can assure you that if you go to the management of NPA, where Mr. Chauke was part, and say, define some of these things, they will not be able to, because they are not people that are working day to day with this kind of things. The people that are working day to day are organized crime prosecutors within DPP offices.
Yes.
If I may, on that, it means finally, when all is done and the matter is in the court, it's a matter for interpretation by the court.
Chairperson.
Applying the law to the facts?
Yes. Chairperson, what happens, we say, well, at the law school they talk about the art of persuasion. So I take my understanding of racketeering and the principles, and then I must convince my judge to see it the way I see it. I must persuade my presiding officer to see the facts the way I see them, and to apply the law in the manner that I want, that I see should be applied.
Yes.
And in relation to these matters, that will be more of the case in the criminal prosecution?
That is correct, Chairperson, yes.
One of the conclusions by the DCOC team is that if indeed there was racketeering towards 2012 or 2011, the number of people killed went down, so that indicated that the enterprise is dying, and therefore there is no need to continue with racketeering charges. I may not be quoting it verbatim, but I know that is one of the conclusions that they came to.
I remember so, Chairperson, yes.
Is that the correct conclusion?
That is not the correct analysis of the principle. I differ from it with the greatest of respects.
I think my junior will find that portion, but it's exactly as you remember, Madam
Yes.
Baloimer. Yes, yes. Well, explain why you differ. That's the point of the question.
Chairperson, the fact that crime goes down, or the regularity of the occurrences just go down a bit, is not an indication of the conclusion or the non-existence anymore of the enterprise, because all that the law requires is, let's have one or more incidents that are continuing, that are ongoing. If I have one or two incidents that are, no, not one, two or more, that are continuous, that have a pattern, that are repeated, then I'm squarely within the definition in poker, and I'm fully entitled to proceed on a racketeering charge.
Yes, the passage that is relevant. I'm not sure if the Cook report is in your bundle. It's not. Okay. I just wanted to be brought to your attention so that I can reference specifically paragraph 190.6, which is page 69 of the Cook report.
In Chairperson, in which file do we find the Cook report?
I think just use mine. I've got two.
Thank you.
Yes. Madam Chair, I'm not sure where the panel has it.
We have those loose ones, but they are lying somewhere. We will find that. You can go straight to the paragraphs.
Yes. Thank you, Madam Chair. So if you go to page 69 of the report, the pages are at the bottom left.
I see them, Chairperson.
Paragraph 190.6. Can you just read that for the record?
Paragraph 190.6.
Yes.
If one has reference to the evidence as contained in the dockets, the alleged enterprise was on the verge of extinction. In 2011, the accused are only charged with 2 racketeering acts as compared with 9 racketeering acts in 2008. To show a continuity, the racketeering acts must include a specific thread of repetition extending indefinitely into the future.
Yes,
Yes,
that's the question you have to answer. Why are they wrong there?
Chairperson, when you look at and that's in my view just basic interpretation of statutes by Cochrane. When you look at the entire tenure of the legislation, the entire legislation, it is intended to prevent organized crime, the perpetuation of organized crime. Now, when for one reason or another, the crime stats goes down, you cannot say, well, because the fancy boys are no longer committing offenses as regular as they used to do. Now I'm not charging them with racketeering. So the regularity or the extent of commission of these offenses does not necessarily mean you have reached your goals. So even if the specific threat of repetition does not extend indefinitely.
Yes.
The fact remains, the offences are being continued. So my view would be that even though the continuity of the racketeering acts are subsiding and not continue indefinitely, it still fits the definition of the definition that we find in the legislation.
No, but I mean, assume for the benefit of the Tikok panel, the best argument they can put up, right, is that the racketeering has ended. Assume the evidence is that it's ended. The enterprise came to an end. So if the enterprise was a gang called the Fancy Boys,
Yes.
the Fancy Boys were all killed,
Yes.
right, and or the leaders were killed. The question is, can the NPA say, we are charging you because for 10 years you were engaged in racketeering, for those who survived, those members of the Fancy Boys who survived? Even though
Perfect.
it's ended.
Perfectly, the NPA can still, because it is elimination of crime that you are focusing on.
Yes. And this is the point about the Tikok panel saying it must extend indefinitely into the future.
Cannot be.
Yes.
Because
After you may proceed
Because-
to elaborate.
Chairperson, what I was going to say is, for the members of the deceased families of those incidents that have occurred, if you say in 2012 there is no other incident, what do you tell them? Because you should be able to give them an answer. So accountability in terms of the legislation, insofar as my view, the analysis that is in the Tikok report with respect is incorrect.
I suppose, as you correctly put it, it's also the matter of interpretation. You have to look at the intended purpose of poker, first thing. Not so. And I don't know whether you have the same thing in Xhosa or Zulu, Advocate Batohi. In Setswana, we will say, Molato ga o bole.
Yes, of course we do.
You have committed these crimes 10 years ago and stopped committing them, but that crime remains.
It remains.
It doesn't get rotten and to say, I'm no longer going to prosecute. That's why we say, Molato ga o bole.
That is correct, Chairperson. Even that rape victim some 15 years ago in the adulthood still remembers that I had gone through this experience that no one is supposed to be exposed to. So Molato ga o bole, definitely we as a NPA, constitutionally we should pursue all molatos, all offences we should pursue.
Yes. It's called
Without-
Icala Alboli.
Without fear, favor, or prejudice. Yes, Chairperson, Icala al-bole.
Yes.
What do you say, Advocate Batohi?
It's called Icala Aliboli.
Ichala aliboli.
Yes.
Yes,
So it's the same
it's
thing.
the same as Molato ga o bole.
The person who should be told that is the current NDPP. Gladly think that he doesn't have to deal with this.
I suppose he's a Motswana, he knows that.
Oh, okay.
So I don't know, but I'm sure he understands that.
Thank you. Maybe you should just keep the panel report because at some point we'll come back to it. Now,
Thank
just to back to the definition. So it's planned, ongoing, continuous, or repeated. And then there's another term, participation or involvement. So the legislation requires that you participate actually
Yes.
or you are involved.
Yes.
What does that mean?
You see, Chairperson, poker was directly aimed at those people who do not participate, who are seen no way, but who fund these terrorist activities. So you fund and but you are never on the scene. But you make it possible for this for this kind of offences to be committed. So you don't necessarily have to participate You can participate physically and be there, but even those that get involved indirectly, in a way of funding, in a way of supporting, in a way of encouraging, they are included in the definition.
So it's the participants and the enablers.
That is correct, Chairperson. Yes.
Yes. In fact, that term is defined very crisply and powerfully by the Supreme Court of Appeal at paragraph 348 of your statement. If you just go up one page.
In S versus Asian,
Yes.
the Supreme Court of Appeal explained the difference between the two offenses. The essence of the offense in subsection E is that the accused must conduct or participate in the conduct of an enterprise. Actual participation is required, although it may be direct or indirect.
Yes. Then continue that.
In that respect, the subsection differs from subsection F, the essence of which is that the accused must know or ought reasonably to have known that another person did so.
Yes.
Knowledge, not participation, is required.
Yes. So just to come back to the point we're making, that we are targeting actual participants,
Yes.
direct or indirect,
Yes.
but also enablers.
Enablers and those that do not participate physically,
Yes.
but who make it possible for those conducts to happen. So if you're looking at the fancy boys that are committing robberies, but there are traffic officers who are making sure that they travel safely. They, even when they have their loot, they make sure that they get safer and faster passage through the traffic. Those enablers you can still charge with racketeering.
Yes. So just go back then to Keto Manu. This concept of being a participant or an enabler.
Yes.
That's what you call involvement.
Yes.
How do you apply it to those facts? I mean, the big name that we've been talking about, I'm not sure if it's a big name, but it's a common name. It's that of Major General Boysen.
Major General Boysen, in our view, managed the activities of the Keto MENA. And, well, we have instances where he also participated.
Yes.
Yes. So for those incidents where he participated, there are those that he participated directly and those where he participated indirectly. But
how would he have participated indirectly on the facts we've seen?
Let's say let's look at the minimal, those incidences where he was not there.
Yes.
Because what he does is he makes sure that AIA is redundant. We remove AIA from there. We make sure that they have vehicles. We make sure that they have all the resources, and we make sure that they have the legal system, or the police system works on the basis of informers.
Yes.
That are some of the people that you live within the communities that know that crime is being committed. So they make sure Keto MENA was structured in such a way that they have an informer network that finds information. You know, even when Ndimande ran to the northwest, to Rustenburg, they were able to sniff and know that he is hiding somewhere in Rustenburg. Even though Makojela was hiding out in the Free State, when he came to Pietermaritzburg to collect money from his taxi operations, they had a strong informer network to know his movements and to be able to track and trace him wherever he goes.
But there's also the other element which we looked at last week, which is impunity.
Oh yes.
These were untouchables.
Untouchables. You know that when you do anything, nothing will come your way. You have protection.
Yes. And at a senior level, could he provide that protection?
General Boysen at the senior level was a cushion that they required to ensure the continuity of the activities.
Now, it says participation or involvement, and then in any offense referred to in Schedule 1,
That is correct.
and includes at least 2 offenses referred to in Schedule 1.
Yes.
And
So that's
what-
why I said you need 2 or more offences.
Yes. Now, this is Schedule 1 of poker,
That is correct.
or Schedule 1 of the Criminal Procedure Act.
No, it's Schedule 1. When it refers to a schedule, it's of the same legislation.
Yes. Now, I don't know if we have the Act here, but I think it's necessary to go through the offenses in the schedule.
Whilst you are looking for that, Advocate Mayema, just for clarity, the Section 21E and read with 21A are not mutually exclusive.
No, they are not, Chairperson. Yeah.
They
Because
are not.
they are not mutually exclusive. Because the one is managing and the one is participation in the activities of an enterprise.
Computer.
So we see, we charged General Johan Boysen with both 21E and 21F.
Yes. Do you have, you don't have the schedule? Okay, I'll organize a computer to be put in front of you to go to Schedule 1.
Before you do that, Council, now as regards the Katomena predicate offences,
Yes, Chairperson.
in relation to this exclusivity that we're talking about,
Yes.
given that the racketeering charges were withdrawn
Yes, Chairperson.
by Advocate Batohi,
Batohi, yes.
and instructions was given that the DPP case at the end should proceed with the predicate offences.
That is correct, Chair.
I suppose only in relation to the accused people, persons, who would have been listed in those specific dockets.
That is correct, Chairperson. Who would have actively participated in those, unless if on the basis of common purpose they can link somebody other than the one who was physically on the scene.
Yes, that's where I was going
Yes,
to. Yes. So if the prosecution team in the DPP, KZN, would then have found that the principle of common purpose kicks in,
Yes,
implicating also Major General Boysens,
yes,
given in one of the dockets where he was directly involved
that is correct, yes,
at the scene,
yes.
then he could be then charged under those predicate offences,
That is correct,
under
Chairperson.
the principle of common purpose.
That is correct, yes, yes.
Thank you, Madam Chair. Do you now have Schedule 1? Of poker?
Oh, do you have the schedule? Thank you. I do, Chairperson.
Yes. I mean, there are 34 offenses there.
That is correct, Chair.
Yes. Now, so are those the schedules that are referred to in the definition of a pattern of racketeering offenses?
That is correct, Chairperson. It's,
Yes.
Should I read the offense?
No, well, my learned friend just says to me that it's not necessary because we can take it to be common cause that that's the schedule.
Yes.
And what you need for poker is participation in 2 or more of those offences.
That is correct, Chairperson. Yes.
Thank you. So you may return the computer.
Thank you. It would be handy, though, to
To keep it.
to keep it and go home with it.
Thank you. Now,
Thank you, Chairperson.
so is the evidence that what you need to establish a pattern is a participation of an individual in 2 or more of those 34 offences?
That is correct, yes.
Yes. And then it says, of which one of the offences occurred after the commencement of this act, and the last offence occurred within 10 years, excluding any period of imprisonment after the commission of such prior offence referred to in Schedule 1. So what does this mean? That you've got a 10-year window to charge a person for racketeering?
That is correct, yes. 21E and 21F. Remember, it only deals with the racketeering offences,
Yes.
and not any predicate offences, if that would be murder or yes.
Yes. All right. So how would that apply to the current scenario? I suppose they were charged even if the charges were withdrawn. So they were charged within a 10-year window.
That is correct, Chairperson, yes.
Yes. Okay. Now, that takes us to paragraph 351. A distinction between section 21E and 21F. Can you just take us through those and the sub-paragraphs, 351.1 to 351.3?
Chairperson, at 351.1, the offence of racketeering under poker is distinct from and can be charged in addition to any underlying predicate offences that comprise a pattern of racketeering. I usually end at the pattern of racketeering activity, because that's where it ends. But here, pattern of racketeering. It is for this reason that the indictment in Ketomena included charges of racketeering and distinct and self-standing charges of predicate offences.
So just explain what that means when you say, because we debated this with Advocate Batohi, she didn't really commit to a position either way, which is, what is the issue in this case that we are dealing with? Is it only poker or poker plus predicate offences? And then she kept on saying, well, the predicate offences are part and parcel of poker.
Well, the racketeering offences are count 1 and 2. They are self-standing. They are charges by themselves.
No, what I mean is this: in order to prove, in other words, to prove racketeering, you will have to prove the murder. If you are saying the predicate offence is the murder.
Yes.
That's the point I'm making.
You will have to prove all the predicate offences, because by proving the predicate offences, then you will be proving that over a period of time. You will be showing that it is ongoing, continuous, repeated over a period of time. In that way, then you are now in the element of a pattern of racketeering activity.
So it's a bit misleading to say that this case is not about the predicate offences, because the case is about the predicate offences.
It is about the predicate offences.
Yes. Now, you were still at, sorry, I stopped you at...
Before I start with the accordingly.
Yes.
Accordingly, if an accused is not ultimately convicted of racketeering, it does not follow that he will not be convicted of the underlying predicate offences. So if your evidence before court would fall short, and the court would not be convinced that there is sufficient for racketeering, the court will still be at liberty to convict
in
you
other words,
of
if a court
the
says
predicate offences.
you've committed murder once, but I cannot find that it was continuous,
Yes.
you are still guilty of murder.
You're still guilty of that kind of murder.
Yes. I mean, this is where one of the things I don't understand in this case, because they just withdrew everything.
Strange, very strange.
All right, 351.2.
351.2, Chairperson. Participation in the enterprise and management of enterprise are not mutually exclusive. That is the point that the Chairperson just asked me to elucidate on earlier. 351.2.1, Section 21E caters for a situation where an accused manages the enterprise and participates in a pattern of racketeering through which its affairs are conducted. But the emphasis there is manages the enterprise.
Yes, now, just to come back to this particular case, you had identified, I think, 5 managers.
That is correct, yes.
We can go through them because I need you to explain to the panel why those 5 individuals were identified as managers. They are
Chairperson, they are on GSM 1-22.
what page?
Page 1-22 of the statement.
Sorry, what paragraph?
Paragraph 71.
Yes, that sounds correct. Yes, that's where you've identified them. Just take us through each one of them and explain why they were the managers.
Chairperson, all of them except Van Tonder were section commanders.
It can't be all of them because Mr. Boysen was not a section commander.
And I was, no, it can't be all of them.
That's why I'm saying just take us one
individual. All
Yes,
right.
yes.
Let's start at 71.1. Johan Boysen was the provincial commander of organized crime. But now, instead of being in the provincial office, he then removes Aya, who's the head of Devon organized crime, to whom Ketomena's serious violence unit has to report. He then becomes he assumes the role of Aya. So all of the section commanders then would then report to him, and he facilitates their activity by making sure that they have equipment that enable them to do their work. Now,
I mean, is there evidence that Aya was actually removed? What do you mean when you say he was removed?
he was rendered redundant.
Yes.
So although he was there as the head of Devon organized crime, they would jump him. They would jump him insofar as decisions and everything. When an incident would have happened, he would hear it on the radio. Unlike Johan Boysen, who would hear it from the members, from Olivier, and then attend the scene. But Aya would be the commander in name, but not in real fact.
So would you describe him as having been the de facto head?
As the de facto head, yes.
So that covers Major General Boysen.
Neville Eva was known for his attention to detail.
Yes.
So he would make sure that make sure that all the scenes are doctored in accordance with the wishes of the enterprise. He'll make sure that there is a firearm that is placed there. He'll make sure that on every operation there are members that would do the guarding of the scene,
Yes.
protect the outside, and there would be sufficient of the members of the penetrating team. The penetrating team, Chairperson, remember, are those that I said they are at the door and they identify themselves, and if you don't open as soon as possible, they will make sure that that door comes down and they enter.
So in that sense, he's playing a management role.
He's playing a management role to ensure that that happens. Now, Olivier was the one who was the head of serious violent crime.
Reported to
He's the one that was supposed to be reporting to Aya.
to Mr. Ayer, yes.
Yes. Now, instead of reporting to Aya, he reports to Johan Boysen. Lockham was also one of the commanders who also made sure that all the team members are available whenever they are required. Whenever there is information that comes from the informer of any of them, then he would make sure that whoever has to be on duty gets on duty, and he would ensure that they have a sufficient number of officials at that activity to deal with whatever challenges that comes out there.
The last one is Mr. Van Tonder.
Mr. Van Tonder was the one who was he's predominant in all the activities. He's the one who was mostly present in all of them. But he was a trusted soldier of Johan Boysen. Johan Boysen will trust him with all the information, and he will make sure that whatever activities that they have planned are executed to the satisfaction of the wishes of Johan Boysen.
Yes, okay. Thank you. So in that sense, these were playing a management role.
They were playing a very crucial management role of the activities of the
It
enterprise.
sounds like there were different facets, but nevertheless, it's management facets, because
That is correct, yes.
One is managing informers, one is managing the actual scenes, one is making sure that the logistics for operations are
Yes,
undertaken, and then
yes.
there is the overall supervisor.
Yes. And the overall supervisor also ensures that you manage the, what do you call it? The reputation of this team, so that also insofar as the media is concerned, there is no negative reporting about Ketomena activities.
Yes.
You have your Karima Browns who will report negatively about Mr. Chauke and I in the media. You have all of that, that makes sure that. Yeah.
So who was responsible for making sure that you receive positive media coverage? The unit receives positive media coverage? I didn't get that.
No, I'm saying Johan Boysen would also make sure that the reputation of the Ketomena remains intact.
I see.
To ensure that there are those in the media houses that would report in accordance with the narrative that they were pushing. Your Karima Browns, there are a number of them. There are, I got the Coke report as a result of one of the media people asking me what my comments are. I've never received a copy from the NPA, and when I received it, then I make sure that I share it with the Advocate Chauke and most of the other teams that are referred to in the report. So very strange that a report that deals with the work that you've done within the NPA is not only the compilation thereof is not only shared with you, but up until finalization, I hear about it from the media.
Yes. Thank you.
But then why would you think that that information would have been given to the media by Major General Boysen?
Chairperson, I'm not saying it was given by Major General Boysen. All I'm saying was it's a report that was generated within the NPA about work that I have done myself. So they expected at some stage to say, Mama, you're saying there's evidence. Where is this evidence? Show me. The dockets are here. Come show me where is this. Where is this? Particularly with the Rodney Dikok, who was very close to me. I had expected him to pick up a phone and confront me about anything. I would not go to Cape Town and leave Cape Town without visiting Rodney Dikok in Cape Town. So I would have expected if there is anything that is within the institution that affects the moving of his eyebrow, he can pick up a phone and say, "Maima, what is happening here? Can we sit down here and talk about it?" We could sit down and talk about anything and everything. But he compiles a report about this. There are things that I have done that he doesn't understand, that he finds strange, but he doesn't confront me with that. So I found that very strange.
So the disclosure could have been made by anyone within the NPA.
That is correct, Chairperson. But all I'm saying is, Audi Alterem Patem says, you hear the other side. Now you compile a report like this where you rubbish the work that I've done, yet you don't give me an opportunity to explain the rubbish that I've done. So I would have expected at least to say, what is this thing? It doesn't make sense. Because as lawyers we differ, judges differ, but at least engage, hear the other side.
Maybe let's just let's just talk about process and not about expectations because of the relationship that,
Oh, yes.
that you have
With
or
him.
you had with him.
Yes.
When one reads this report, it appears like it's a product of a review of the work that was done by your
By my team, yes.
That's right.
Chairperson.
Now, what is the process in the case where someone is in the NDPP, in particular, the NDPP herself or himself, whoever would be occupying the position?
Yes,
What
Chair.
is the process if someone wants to review the work that you have done?
Chairperson, if one looks at section 179 from subsection 2 to subsection 5, in fact, the review powers of the NDPP are in section 179 sub 5. The review would be instigated by a written complaint or either a complaint from an accused person or a complaint from a family of the deceased. A participant would complain, and then a team would be put together to review the decision that was taken.
Yep, but now I think we must talk about a review that is being done at the instance of the NDPP without even any complaint having been lodged.
1795.
But upon perusal, the NDPP, like it is the case in this particular case, that it was done at the instance of the NDPP.
Yes.
Let's just talk process. What is the process? What are they supposed to do, especially in relation to the prosecution team? Thank you.
Chairperson, what I would have done if the national director had asked me to do this, I would
No. I think the question is not what you would have done. It's what is the
what
process?
the process is.
Yes.
Yes, thank you.
Well, I would have followed the process, but the process is a team is put together, and the team then will consider and evaluate what is the evidence that is available. Now,
Mr. Mayama, I think we're going sideways again.
are we?
You've told us that the process is outlined in section 179, subsection 5 of the Constitution.
Yes.
What does that section say? You can find the provision and read it for us.
Section 1795D. The National Director may review a decision to prosecute or not to prosecute after consulting the relevant Director of Public Prosecutions and after taking representations within a period specified by the National Director from the following persons: from an accused person, from a complainant, from any other person or party whom the national director considers to be relevant. Now, in fulfilling the responsibilities in section 17795D, the national director would then put up a committee, a team.
But I mean, was this process here followed? I mean,
No, it wasn't followed.
this,
It wasn't followed. There is no representations within a period of time from an accused person, from a complainant, or from any other person that the national director considers
Yes.
relevant.
Thank you, Advocate Mayema. It will help if you were to just try to answer the asked questions.
It is difficult, Chairperson, when you when you sometimes have more information and instead of
Your witness will tell you that one day.
thank you.
Thank you, Chairperson.
Thank you.
Thank you. I'm sorry, I'm going to take you a page back because I was slow in raising my question. Advocate Mayema, you listed the 5 managers or the 5 people that you regard as the managers of the Katomena enterprise.
That is correct.
And you also indicated why you regard them as
Managers.
as the managers. But what I'd like to know is, where do we get this information, or did you deduce it from the dockets? What, for example, I'll give an example with Lochem. You say Lochem always made sure that whoever has to be on duty is on duty. Where and how did you get to this conclusion about Lochem and his participation? Thank you.
Chairperson, what we did is we look at the organogram of the provincial organized crime unit itself, and then we looked at the composition of the SVC unit, serious violent crime unit, and then we looked at the various incidents in which they participated, and we analyzed the roles that they engaged in from incident 1 until incident 23, and then we could see from the incidents that these are the particular roles that all of the managers were predominantly taking in the activities of the enterprise. So it's not only the organogram of the provincial organized crime itself, organogram, the activities themselves, and how the activities were executed. That gave us an indication of the roles that each of them undertook during the incidents.
The organogram does not make it clear that these people play this role. The organogram tells us that the provincial commander of organized crime, KZN, is Director Boysen.
That is correct.
That's all it tells us.
Yes.
But you took it further to say, well, with Boysen, already you've led evidence to show that he was managing because he made sure that they have resources, and he would always be there and make sure that the reputation is intact
Protected.
and give instructions.
Yes.
But it is a bit. It is a bit not clear. Let's take Neville Eva. You say he's known for attention to detail, made sure that on every operation there will be relevant members, and but there will be people who can break down doors. But where do we find that information that Neville Eva played this active role in order for us to put him as part of the management of the enterprise.
Chairperson, when you look at how the activities unfolded at the incidents, at the various incidents where they did the raids, you will see that he is consistently the one that guards the scene that is being penetrated, and he's the one, after somebody has been killed, who makes sure that the scene will accord with the view that they were being attacked and it was a justified killing.
So this is taken, this conclusion comes from looking at each and every scene
That is
and
correct.
the participation of these members from the scenes.
That is correct, Chairperson.
Okay,
yes.
thank you.
Perhaps one of the things we will do in due course is that there was a request for further particulars to the charges. You recall that?
Yes.
And one of the questions raised there was precisely why have you identified these 5 as managers?
That is correct, yes.
And you provided an extensive response,
Yes, Chairperson. we did.
which it's too bulky. We haven't included it in the bundle, but we will just make it available. Yes. Thank you. We were still at paragraph 351.2 of your statement.
That is correct, Chair.
And we have finished the part dealing with what is a manager and why did you conclude that the 5 you identified were managers. Can you deal with 351.2.2?
That is correct, Chair. Further, an accused can be charged with and can conceivably be convicted under both Section 21E and 21F. In Prince-Law, the SCA rejected what it viewed as the absurdity of a manager of a multi-billion rand racketeering enterprise who has had minimal personal active participation would only be liable for the minimal participation role under Section 21E and not under Section 21F for the extensive managerial role played in a highly successful criminal enterprise. I note, however, that the SCA has cautioned that in that scenario, care must be taken to avoid an impressive splitting of charges.
Yes, I just want to get the principle out of this passage. A person charged as a manager, can they also be charged as a participant?
If that person executed both roles, yes. You can charge him as both a manager and as a participant.
Because I suppose management is a funny concept because it also includes participation.
Most of the managers, they dirty their hands too, so they participate as well.
No, I'm saying even the way you've described management, where someone makes sure that a gun is planted.
Yes.
That is an offense.
That is correct.
Which is in Schedule 1.
Yes.
And therefore it would mean you are a participant.
You are also a participant.
Yes. Or even the organizing of making sure that the vehicle is available, but it's a vehicle to commit a murder.
That is correct.
So which would also be an offense of being a conspiracy to murder.
That is correct, Chair.
So that's the point I'm making. I'm trying to understand in 351.2.2 about being a manager and a participant is not...
it's not mutually exclusive.
Yes, you debated that earlier with the chair.
No, I didn't debate.
Well, you explained it.
I explained. I elucidated, Chairperson. I would not want to be in the position where I do that. I would be run over by a train.
Okay, that's fine. Thank you. All right, so that's the emphasis on that paragraph.
Yes.
And then 351.3.
The racketeering enterprise and the pattern of racketeering activity through which it conducts its affairs are distinct. A pattern of racketeering activity may be proven, but if that activity is not conducted by an enterprise, a charge of racketeering will fail. That said, the SCA has explained that proof of pattern may establish proof of the enterprise.
Yes, now just stop there because it's one of the areas in the DeCock report if you look at their summary at paragraph 190,
is on page 69.
yes, 68,
She started at 68.
190.1. It's one of the reasons they say that you got the law wrong. It's because their view seems to be that an enterprise must always be separate from the racketeering activity. It says there is no evidence to establish the existence of an unlawful enterprise. Let's forget about the unlawful part. You've explained that
Yes,
they got the law wrong here.
yes.
But if you remove unlawful, you just say enterprise separately from the existence of a pattern of racketeering activity. What is your response to that?
There is no evidence to establish the existence of an enterprise separately from the existence. There is ample evidence to show that, because I mean, if you agree that, if you hypothetically speaking agree with the prosecution team that the Ketomena serious violent crime, being a lawful institution, can constitute an enterprise. If you look at their activities, I mean, the enterprise exists and the activities continue, but the members of the enterprise can be different from any given day, depending on who is available, depending on the resources that are available to the enterprise.
I understand, but I think the point here that they were making in 190.1 is that your conception of the enterprises collapses an enterprise with a pattern of racketeering activity, whereas the two must always be separated. I understand you're saying on the facts that's not what you did.
Yes.
You separated the enterprise from the racketeering activity.
Yes.
So they got that wrong.
Yes.
But there is the question of law. According to what you say in 351.3, is it always necessary that the enterprise must be separate from the racketeering activity?
No, it is not necessarily always so that the enterprise will be separate from the pattern of racketeering activity.
Because I mean the SCA says proof of the pattern may establish proof of the enterprise.
Exactly, yes.
In other words, you can look at the pattern in order to say that there is an enterprise.
That is correct, yes.
Can remind me, didn't Advocate Batohi actually say that they are interlinked?
I can't say for sure.
Did I miss that point?
I can't say for sure.
I'll look at my notes.
Yes, we will have to look at that, yes. I mean, it's odd because it would always be strange that in order for people to be convicted of poker, you must, in every case, try and find that the enterprise pre-existed the pattern, you know.
Well, Chairperson, in the cases that I had dealt with, particularly the one that I dealt with Judge Hendricks, J.P. Hendricks, as he now is, we debated this extensively because I had an individual as an enterprise. So to have an individual as an enterprise, his view was that then that individual must be present at all the scenes, or must have had a role in one way or another. But that individual was conducting his affairs in such a way that, you know, he engages different people at different minds to make sure that you know, all the activities that he wanted executed are dealt with, and to make sure that when he deals with individual C, sometimes individual D, who knows individual C is not aware that the manager is dealing with the other one. So the enterprise and the pattern of racketeering activity can coexist.
But don't they necessarily coexist? Because as a prosecutor, what you see is the commission of crime.
Yes.
What we don't see is whether behind the commission there's an enterprise.
Yes, but what you do is when you then consult with your witnesses and when you look at the complete picture, then you will see it. Because what you do is that we argued in reverse. We, having consulted with the witnesses, having heard what was prepared, and having looked at what happened at the scene, then you can be able to say, this is how it unfolded.
I understand that, but I'm saying this idea that this panel has that the two are to be segmented in every instance.
Not this panel.
Sorry, not the
Tikok
panel. The advocate Tikok panel has this idea that the two must be split at all times. Strikes one also as being nonsensical, because what a prosecutor comes across is crime in the first instance.
Yes.
It's only when you try and unpick the elements of the crime that you see that there is an enterprise.
That is correct.
So the two will always be interlinked.
Yes. All the time.
Yeah.
Yes.
Then you deal with paragraph 352, where you set out who was charged with what. Maybe you can deal with that very briefly, because we've covered that quite extensively.
Chairperson, as noted in the indictment in the Ketomena prosecution, comprised racketeering charges and underlying predicate offences. In summary, of the 29 accused persons charged with racketeering under poker, 5 accused persons were charged as managers of the enterprise. The 5 I have referred to earlier.
Yes.
As the 5 were charged as managers in terms of 21F, and as participants in the racketeering enterprise in terms of 21E. 19 accused persons were charged as participants in the racketeering enterprise in terms of 21E of poker. 5 accused persons were charged under both section 21F and 21E. Each one of the 30 accused were charged with a predicate offense. In total, the accused were indicted for 114 predicate offenses, comprising 19 counts of murder. We refer to those kinds of murders in the brackets. 8 counts of housebreaking with intent to commit murder, and those are referred to. 1 count of attempted murder, count 83. 3 counts of assault with intent to do grievous bodily harm, counts 4, 41, and 43. 1 count of malicious damage to property, count 45. 6 counts of theft, counts 24, 30, 50, 57, 93, and 108. 3 counts of pointing of a firearm, which are counts 26, 42, and 44. 23 counts of defeating or obstructing the courts of justice, which are counts 5, 12, 18, 23, 29, 34, 38, 51, 52, 56, 61, 66, 69, 79, 90 to 92, 97, 101, 103, 107, 112, and 116. 26 counts of unlawful possession of a firearm, which are counts 6, 10, 15, 16, 21, 27, 32, 36, 46, 48, 54, 55, 59, 63, 67, 73, 75, 77, 84, 86, 88, 95, 99, 105, 110, and 114. 22 counts of unlawful possession of ammunition, counts 7, 11, 17, 22, 28, 33, 37, 47, 49, 60, 64, 68, 74, 76, 78, 85, 87, 89, 100, 106, 111, and 115. In terms of the indictment, the accused included accused number 1, Boysen, the commander of Ketomena SVC, and organized crime, later the DPCI unit. We refer to them as the Ketomena unit. Accused 9, the section commander of the Ketomena unit. Accused 6, Neville Eva. Accused 15, Lockham. Accused 16, Van Donder, as group commanders of Ketomena. 353.4. The majority of the remainder of the accused were members of the SVC section based at Ketomena, whilst other accused were based at other units of the SAPS within the KZN, including Port Shepstone Organized Crime Unit. Chairperson, in the indictment, the predicate offences were grouped by incident type. Namely, we had taxi violence related killings. We had ordinary civilians or suspects, and then we had ATM bombing suspects.
Just explain that. What is that about? It's categorized like that in the indictment, but what was the significance of that?
Well, when we analyzed the incidents, what we did was we saw that some of them were taxi violence related. Means they come from Kwama Pumulo Taxi Association and Stenga Taxi Association. That feud. But we saw some of them ordinary civilians, people like Ba, who were just ordinary civilians who were considered by Ketomena as ordinary criminals. And then we had those suspects that were involved in ATM bombings. So those are the different categories of offences that we ultimately included in the indictment.
So it's people being killed because they are suspected of being in an ATM bombing.
That is correct, yes.
And someone else being killed because they are suspected of being, it's alleged that they are suspected because we know there is evidence showing that from Mr. Zungu, that these people were not even suspects.
But were not even, yes. But then there would be ATM bombing related offences, taxi violence related offences, and just others that we saw just as ordinary criminals.
Yes, thank you.
Across the indictment, each indictment were made up of the following recurring elements: a lethal operation pleaded as murder or housebreaking with intent to murder, plus murder, occasionally attempted murder. 335.2, possession of offences charging the same accused person with unlawful possession of firearms and ammunition used in that incident. Post-incident misconduct, almost invariably pleaded as defeating or obstructing the course of justice by staging the scene, typically by planting a firearm on the deceased. Collateral offences where applicable included assault with intent to do grievous bodily harm on surviving suspects, theft of some of the items that they will see, the money or jewelry, malicious damage to property which would happen when the penetration team enters the house during the course of the raid.
Yes. Now, these features, there are 4 features of the offences you've identified.
Yes.
Being a lethal operation or a deadly operation.
Yes.
Possession offences, and then doctoring of a crime scene.
Yes.
And then the collateral. I mean, we have many wives of the deceased saying they were beaten up or assaulted during the incident.
That is correct, Chief.
Now, is this relevant at all to the point you made earlier that what we saw here is that it was the same offences being committed across time and space by the same group of people?
By the same group.
In the same method.
In the same method, continuously, with the knowledge that we have cover, we have protection from general police.
Yes, but I mean, would this fit the frame, the 4 features that are identified, the frame of a pattern?
Yes, it would fit a pattern of racketeering activity perfectly. Yes.
And then 356 and 357, if you can deal with those paragraphs.
356. Each incident generated a cluster of counts, and it is the repetition of these clusters that the prosecution relied on to demonstrate a pattern of racketeering activity.
This is the point I was trying to get you to. Yes. That when you look at these activities and with the features, the 4 features that are there, that are present in all of the 23 instances,
Yes.
the most extraordinary thing. All of the 23 that you charge have those 4 features.
All of them have, yes.
Did you find out how this happened? I mean, I couldn't understand it myself, how in every scene there is a coordinated lethal attack.
Yes.
There is a weapon found.
Yes.
There is an assault committed on all of those people who witnessed it.
I don't follow your.
I'm saying, did you find out how it happened? Like, was it centrally planned?
It
And
appeared.
How did it happen that it had exactly all of the 4 features across 23 separate instances?
You know, it had to have been planned to, to perfection, to come out in the manner that it came out. Because in all of the incidents, when I made the presentation to EXO, I said, if you go through 4 incidents, then you know what happened in respect of all of them. Because it happens in the same way. It happens in, all of them happens the same. And it ends up in the killing either of 1 or 2 or 3 of the suspects, or all of the suspects that they were dealing with. Yeah, so it's,
The other oddity is that in none of these 23 instances is anyone actually arrested.
none is arrested. Not a single of the police vehicles are damaged. Not a single of them are injured.
Yes. And Advocate Batohi then says this is not a pattern.
Oh, it is. If nothing fits the definition of, this is the perfect definition of a pattern of racketeering activity. I would have marveled the opportunity of presenting this case before a judge.
But you can still apply. I heard that there's a section, I don't know, section 35 or something, where the NPA can appoint a prosecutor from outside. Is it 38? Section 38. All right. And then anything you want to add on? You haven't dealt with 357.
357 is the enterprise alleged in the indictment was the formal SAPS unit, the Ketomena SVC organized crime, later DPCI unit, with the accused 1, Boysen as a commander, accused 9, Olifir, the section commander, and the group commanders as accused 9, Eva, accused 15, Lochem, and accused 16, Van Tonder.
Yes, we've dealt with 358, which is I started with this when I asked you to explain why they were an enterprise.
Yes.
So unless there's something there that you feel you haven't said that is contained in your statement.
No, Chairperson, I think all that I've said is in the statement.
Yes. And we've dealt with the 359 because you've mentioned that it was not your case that the enterprise was unlawful per se. You accepted
Yes.
that it was a lawful enterprise, but it carried out criminal acts.
Yes.
And then we've also dealt with the next section about General Boysen as a manager.
Manager, yes.
We've dealt with the statement of Colonel Ayer. We don't need to repeat that. We've dealt with the statement of Commissioner Brown. We also
Yes,
don't
we
need to
have.
repeat that. We've dealt extensively with the answering affidavit of General Boysen, so we don't need to repeat that either. What we haven't really covered are the draft statements of Mr. Danikas. We covered one statement, but only for one purpose, which was to establish that there is no need for a statement by a witness like Mr. Danikas to be signed.
there is no legal requirement for that evidence to be under oath, and because all that it requires is information,
Yes.
not a statement under oath.
Yes, but this time, what I would like you to do is just to set out for the panel your involvement in securing Mr. Danikas as a witness and leading up to the point when he signed the statement. And you will know why this question is relevant. It's because there was an allegation that you lied because you claimed that Mr. Danikas is a witness when you knew that he was not a witness. So this is your opportunity to set that out.
Chairperson, with dealing with Mr. Danikas, I made sure that I informed Mr. Matenja that I will deal with Mr. Danikas myself, because having spoken to him twice, the third time I knew that when you deal with him, you ought to be careful. So, General Mabula was in Greece with him and informed me that he has a witness in Greece who has fears to come to the country, but who is prepared to give us a statement. And then, knowing the Mutual Legal Assistance Act and knowing that if a witness is outside the country and if I want to use his statement in a subsequent trial, I will have to obtain the witness statement in terms of Section 2 of the Mutual Legal Assistance Act. I advised General Mabula to obtain a draft statement. And he then came back to the country with that draft statement of Danikas, unsigned. Because what we wanted to do was to look at the statement and then see what is lacking in the statement, see what is unclear, and ask him to clarify some of the things which I dealt with myself. And then during the reign of Advocate Sean Abrams, I will deal with the inside part, because the outside part, the media, to me, were not as important as the inside part. Because Danikas, from the beginning, all the time, it had been our intention to call him as a witness. Yes, his name is not mentioned in the indictment as a witness. We didn't want to mention his name. The indictment specifically says in terms of Section 1443, which allows us not to include names to redact some of the name addresses that will put witnesses' lives in danger. So Sean then said, Advocate.
So that's Advocate Abrams.
Advocate Abrams, Chairperson, my apologies. Then indicated the importance to consult with Mr. Danikas. And then.
So this is just in sequence. This is now after the judgment by Judge Govan, who set aside the racketeering activity, the racketeering certificate.
Yes.
And Mr. Abrams comes onto the scene.
Yes. And
what do you recommend to him as the prosecution team?
Then because of the concerns that were raised by Mr. Danikas, Mr. Abrams and I had a discussion with witness protection, Dawood Adams of witness protection, and the crucial aspect was to go and was for Mr. Adams to ensure the safety and security of Mr. Danikas, to hear from him what his concerns are and how we are going to be able to get his evidence before court. But then we then decided that perhaps we just, witness protection and myself, should just use one trip to go and see Mr. Danikas, which we did in the January of 2018. We then flew to Greece to go and meet Mr. Danikas. We met him for 2 days, and We discussed, he raised all the concerns, and he had a separate meeting with Witness Protection, Dawood Adams, and he had a separate meeting with me. And on the third day, we had a joint meeting, and we took down his draft statement, came down with the draft statement, with the videos and all the information that he gave us in a memory stick.
And did you yourselves watch the videos?
I watched most of the videos, yes. Yes. And then I came and I reported to senior management, and then that's when we commenced the process of obtaining his statement in terms of the Mutual Legal Assistance Act. Yes. I traveled to Durban. I met the chief magistrate there. I presented my application. My application was signed. It was compiled in a proper formal application with diplomatic notes, and then it was taken through diplomatic channels. Diplomatic channels are Department of Justice, goes to Foreign Affairs, and then Foreign Affairs then goes to the embassy. The embassy then channels the application to the embassy of Greece, and the document ends up in Greece. The relevant authorities in Greece then deal with the application, meet Mr. Danikas, they obtain his statement, and the statement is channeled through diplomatic channels back to the country. So I was surprised when I saw Mr.
So just before you go to the point of being surprised,
Yes.
I just want to make sure the statement you're talking about is whether or not it's the same statement at 1A906 at GSM 90. Madam Chair. Sorry, I think I've now missed the page number. It's 1A906. Yes, thank you. There is the original Greek version at 1A923, and then at 1A906 is an English translation.
Perhaps the council, we can adjourn here.
Oh, yes.
And Advocate Mayema will quickly look at GASM 90, and when we reconvene, you can proceed.
Thank you, Madam Chair.
We will adjourn for 30 minutes until 11:45. Remember, you are still under oath, Advocate Mayema.
That is correct, Chairperson.
We will adjourn now.